Hello, everyone, and welcome back to this particular part of the program. We are about to launch into the live oral hearing. A couple of logistical notes. Please be advised that Judge Wolfson's brief overview of the case did not have a keyword after that. I know that we've received a couple of questions on that. And for those of you who did miss the keywords from the beginning programs, please make sure that you send an email to Lanham Quest, Q-U-E-S, at uspto.gov, and we can get that information to you. Now I am going to open this up and turn it over to our distinguished panel of judges, as well as the parties for the TTAB hearing. Thank you.
06, Gang Cow versus Apple Inc. Mark Levy is appearing for opposer Gang Cow. Dale Sandali is appearing for Apple Inc. We've reviewed the record and we have read the briefs. We have two preliminary issues. Opposer filed 6 rebuttal notices of reliance. Applicant objects to these notices of reliance on the ground that the evidence in the notices of reliance comprise improper rebuttal. Opposer does not agree and contends that even if the evidence were improper rebuttal, the board has the authority or discretion to consider it. For purposes of this hearing, the parties should act as if we're going to sustain the objection to the extent that we will consider the rebuttal evidence only if it rebuts applicant's testimony and evidence, but not to support opposer's case in chief. In addition, applicant has filed numerous objections. Because this is a bench trial, and we are mindful of those objections, we will accord the testimony and evidence the probative value to which it is entitled. Opposer's counsel has 30 minutes. Would you like to reserve any time for rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Okay. Now, what is it that you want to tell us today that you could not say in the 55 pages of your main brief and 25 pages in your reply brief? In other words, give us a keynote summary of your case.
I'd be happy to, Your Honor. In September 2015, Apple launched a new software feature for its iPhones that it called Live Photos. And although Apple was not the first to market with this feature, HTC, an Apple competitor, actually beat them to it by a couple years, this was still relatively new technology. And in its first and apparently only television ad in early 2016 for the feature, Apple told consumers that its Live Photos feature produced live photos. And Apple explained to consumers exactly what those live photos are. Apple said in its ad, quote, "Live photos are more than just photos. They come alive when you touch them, and then they go back to still when you let go."
Well, counsel, counsel, couldn't consumers seeing that commercial interpret that as Live Photos brand software?
No, Your Honor, because in the ad, Apple is actually talking about live photos precisely as the things produced by the software. In the ad, it says that live photos are more than just photos. That's not a reference to the software. That's a reference to the output of the software, the media, the new hybrid photo video media produced by the software. And so Apple's lawyers may argue that live photos could mean anything, and that the juxtaposition of live with an inanimate object is incongruous. But Apple has told relevant consumers exactly what live photos are. They are still photos that have life or animation. So, and that is really the crux of this case, Your Honor. Apple's decision to call the output media produced by its Live Photo software feature Live Photos was a fateful one for purposes of its application to register live photos as a trademark for its software. Because Apple's own definition of a live photo, the thing that the software produces, a still photo that comes alive when you touch it, tracks pretty exactly the dictionary definitions of live and photo that we have put in evidence for your consideration.
But Mr.
Namely,
Levy,
photo.
the photos don't actually come alive, do they?
The photo, well, no, they don't actually come alive, but they have the capacity. Remember, live is defined as having life. And that is according to the dictionary. And also according to exactly the definition that Apple is adopting in its own advertising, that the sense of something that has life, spirit, or animation, according to Merriam-Webster. And that's the important point, because in adopting that, the ordinary definitions of live and photo in the context of Apple's goods, which is of course critical here, that it has to be, you have to look at the meaning of these terms in the context of Apple's goods. Apple has adopted a generic name for the key aspect of its live photo software. And
well, counsel, first, there's no definition, there's no dictionary definition of the term in its entirety, live photo. There is just one from the Computer Encyclopedia that associated it with Apple. But then this gets into an interesting question, because if you have us take the definition of live and the definition of photos and put it together, I don't know, I'm almost having to do a multiple step reasoning process to get to the fact that it's an active photo, or it's a photo in motion. And so I'm wondering if I'm looking at this, and if it weren't for the third party usage, I might think that live photo is suggestive. So if at the start live photo was suggestive, would that prevent it from becoming a generic term subsequently?
No, it wouldn't, Your Honor. Even if you thought it may have been suggested intrinsically, of course, any mark can become generic over time through usage. That's just the nature of generic marks. And in fact, many historical generic marks, that some of the most famous examples of generic marks, like aspirin and escalator, all started off as distinctive brand names. So my response is even if you were to think that intrinsically it was suggestive, that does not resolve the issue. But I'd submit to you, Your Honor, it is not suggestive. There is no active reasoning required to determine what live photos are, because Apple, with its marketing prowess and its advertising, has told us exactly what they are. It has told us that they are still photos that come alive when you touch them, and that's so, you know, all of this.
Well, counsel, applicants, I guess, in-house counsel said that they used uppercase letters to signify, in its advertising and promotion, to signify that this was a trademark. How would you respond to that argument?
Well, we explored that in Mr. LaPearl's cross-examined deposition, Your Honor, and Mr. LaPearl conceded in his deposition that Apple uses initial caps for all kinds of features in its iPhone, many of which, if not most of which, it does not claim as brands or trademarks. Some examples. Apple's capitalization. Apple uses. So, for example, in his deposition, Apple uses initial caps for some features that it believes that it are Apple trademarks like Liquid Retina and True Tone and Live Photos, for example. But it also uses initial caps for a whole variety of other features in the iPhone, like haptic touch, like ultra wide, like depth control,
But
auto
Mr. Levy,
adjustments.
what about when Apple referred to live photos and still photos together? Wasn't it the case that live photos had initial capitalization, but still photos did not?
Well, that I think that's true, Your Honor. But that, as I'm pointing out, I don't think that matters. That Apple's decision to use initial caps with live photos, Apple itself does not use that to indicate that something is a brand. And so the fact that Apple juxtaposes live photos with initial caps compared to still photos that doesn't have initial caps is not sufficient to show that Apple claims it as a trademark, because Apple does that procedure with many features, other features of the iPhone, which are also capitalized, which it does not claim as brands.
Mr. Levy, I wanted to shift topics for just a moment and ask you about the first step in our genericness analysis, which is naming the genus. And often the genus is the identification of goods or services, but I think in this case you are arguing that we should deviate from that and use, I think the suggestion is software that adds animation or life to still photos. Can you talk a little bit about why we need to deviate from the ID, why that's necessary?
Well, actually, it's not. Well, I'll tell you why it's appropriate. I don't think it's actually necessary to the decision, which I'll explain. But I believe that the appropriate genus is the narrower genus, and the reason is very similar to the reason that the board adopted exactly the same approach in another recent case involving Apple, involved the smart keyboard case from January of this year. You know, in this case, Apple effectively tried to camouflage the generic nature of the mark with an overbroad and vague description of goods. Its description is, quote, computer software for recording and displaying images, video, and sound. Now, if you pause, I mean, that description covers nearly any type of software for audiovisual production. So there's no sense of what this thing really is. It's an extremely broad category. And, you know, Apple's argument that it's similarly, Apple tried a similar approach to camouflage the nature of the good in the smart keyboard case. And the board rejected that based on the evidence in the record, including applicant specimen and its advertising and promotion of the smart keyboard goods. The board wrote, for example, in the smart keyboard case, we need not turn a blind eye to the reality of what is offered by applicants' description of goods as shown by the evidence, including applicants' own evidence, and then the board adopted a much narrower definition, namely technologically advanced keyboards for mobile digital devices. And essentially what we're saying here, Your Honors, is that exactly the same procedure should apply here, that instead of applying this overbroad, vague description, that the more appropriate description is a software function that adds animation to still photos, which is more appropriate and for which Apple has a number of competitors.
But I think you've even pointed in your own briefing to some of the precedent that says even naming the subgenus or naming the key aspect of the genus can qualify as generic. And so I'm not sure, given that, why you're saying it's appropriate or necessary that we would narrow the genus beyond what's in the ID.
Well, you took the words right out of my mouth, Your Honor. That you're correct, of course, that even if the genus even if you accepted the genus as this overbroad description of goods, that because of the Federal Circuit authority that says that only, even if a mark is generic for only part of that genus, and of course, here, a software function that adds animation to still photos would be a subset of this very large genus that Apple has proposed in its description, that you'd come to the same result. So it's not essential to the decision in this case, Your Honor.
Thank you.
But the essential thing here is to understand, when we move to the second step, to ask whether relevant consumers of software would primarily understand live photos to refer to the software or a key aspect of the software. That's the key. That is the critical question in this case. And the primary reason in this case why live photos is generic is because live photos is the generic name of the key aspect of software, namely the hybrid media that the software produces. So again, the key, as we see it, the key question here is whether live photos is generic for the still photos with animation that are produced by the software. And the evidence in the record clearly shows that it is. And I'd submit that the most prominent, the most important evidence here has nothing to do with all of the dozens and dozens of examples and third-party usage.
What is the most important evidence then?
The most important evidence in this case to show that the mark is generic is a combination of the ordinary dictionary definitions of live and photo in relation to Apple's goods, and combined with Apple's consistent definition of live photos as advertised to consumers as still photos that come to life. That together, Apple essentially concedes in its advertising that live photos is the generic name for the output media of its product. The third-party evidence, that other evidence, is merely confirming that Apple essentially was successful in educating consumers that that's what it means. So, essentially this case, because of that, I mean, this case is a little different. I think in important respects, it's squarely consistent with the Churrasco's case concerning, where Churrasco's is found generic for restaurant services because Churrasco's is the signature item featured by the restaurant. Now, that's partially because Churrasco's was a well-known generic word for a key aspect of the restaurant services. Now here, it's a little bit different because live photos was new technology, and relatively new technology. And, I know Apple claims that they coined the name. Well, they didn't really coin the name, but it was still relatively new at the time. But here, the key question is live photos generic for that media? And instead of being an established definition, like in the case of Churrasco's, Apple basically said, here's our name for this hybrid media, and here's what it means. And it decided what that was. It advertised it to consumers, and therefore Apple itself essentially is responsible for creating the generic name for the key aspect of the software for which it wants to trademark.
One of the things that an applicant objected to and as to your evidence is the third-party evidence, the third-party users who use live photos as part of their name or in advertising their camera apps, and then the third-party media, was that there was no evidence as to circulation or how many people saw the apps or bought the apps. So they said there's just it's very little probative value. How would you respond to that argument?
Well, I think you have to look at that evidence holistically. So, the fact, what Apple's essentially done is try to look at every single piece of evidence, and there are dozens and dozens of examples, right? And they're throwing these darts at those. Well, this one, we don't know how relevant it is because we don't know the circulation of it. We don't know, this one is faulty because, it comes from India, okay? Or there are all these, kind of what I call, they're trying to peck away at the significance of the evidence. But you have to, and obviously on the foreign source evidence, I mean, the board has been clear that including in the smart keyboard case itself, that the foreign evidence is absolutely germane, and it's particularly in dealing with evidence from countries like India, where English is an English-speaking country. So, but I think you have to look at that evidence holistically, and because it's
counsel,
confirmatory.
What about there were some third-party users that used live photo for some of their camera apps, and in opposition, applicant introduced some evidence to show that, I don't know, some percentage we're no longer using the term live app or a live photo to advertise their apps. So how should we weigh that evidence that a third party was once using live photo but now is no longer using live photo? Is that something that we should just discount, or is that something that we should consider, but well, it doesn't have as much as weight as a use that was continuing to be used?
Well, I think that evidence has weight regardless whether it was taken down or removed later. The importance of that evidence is to show that people understood live photos in connection with things that don't come from Apple. And the fact whether or not it was taken down later doesn't diminish the fact that somebody thought that when they put it up in the first place. So I don't think that I think the evidence is relevant for what it shows. The fact that it may have been taken down later for reasons we don't know doesn't diminish the significance of the evidence, that what it reflects is that those people actually understood live photos in a generic sense, not just to refer to Apple as a source.
Applicants' counsel is going to argue that was copying. That was third parties trying to make an association with applicants' live photos software and feature. How do you respond to that?
There's no basis for that. There's no basis in the record to that would be pure speculation. We don't know exactly why that is, and in fact, I'd suggest that because it was used generically in reference to third-party sources, that it shows exactly what it appears to show, which is that consumers believe that the mark has is not a source identifier. And this is, again, it is not just these. I mean, there are some very significant pieces of evidence. I mean, we've got a major third-party competitor to Apple, LG, which is using live photo generically in connection with a series of its smartphone models. So, I mean, this is not just one-off, this chat or this message here or there. there's some very significant evidence here of generic usage of live photo, both as a software feature and as the hybrid media.
Counsel,
Well,
you got about a
Counsel,
minute and a half.
Counsel, I have a question for
Um,
you. You speak about the EU IPO Board of Appeal. Why should we even consider that here?
well, we offered that in rebuttal, Your Honor, because Apple in Mr. LaPearl's declaration touted that the mark had been registered in something like 70 countries, and in rebuttal, we felt it was important to put context on that to show that the European Union, which is a pretty significant jurisdiction, had rejected the mark on the grounds of descriptiveness. So that's honestly that's really the main purpose of that. Because I have no time, let me quickly wrap up. The genericness issue in this case really begins and ends with Apple. That essentially, when Apple made the fateful decision to adopt a generic name, both as the name of its software feature and as the name of the media it produces, it just really it destroyed the ability of live photo to function as a trademark. And this case, we think, Your Honor, is on all fours with the Tarasco case, and in the software context, the virtual meeting room case and the cardless cash case that Judge Bergsman authored, where finding that the cardless cash could not function as a trademark for software that produces cardless cash. That's exactly what we have here, Your Honors. And for those reasons, we respectfully request that the board sustain the opposition to Apple's application.
Thank you, counsel. Ms. Sandali, you may begin. I have a question for you first. You challenged opposers' entitlement to a statutory cause of action, and that's what we now that's used to be called standing, but the Federal Circuit has corrected us. So could you explain why opposer does not have an entitlement to a statutory cause of action or standing? And if you refer to it as standing, we'll understand.
Thank you, Your Honor. I think it's really, I'm glad you asked that, because too often standing doesn't get the attention it does. I totally appreciate that standing is a low threshold. We don't deny that. But if ever there was a case where the board was to say, this is an interloper who does not have standing, this is mucking up the trademark system, this is inconsistent with the purposes of the Lanham Act, it's this one. While Mr. Cow has muddied the record, there's basic principles that are important. One, he has never once tried to or offered a product using the words live photos. That was he's owned 2 domains since 2011. That's long before Apple launched its heralded product in 2015. And in those 4 years, he had these apps with nothing on them. They were listed for sale. Only after Apple launched did he put some static images on them. And now they're not, he's taken them down completely. And the products that he does offer, and this is key, his Spin Fun and Spin Explorer apps, first of which came out in 2012. So again, well before Apple, so he could have used, if he, under his theory, live photos then. He did not. But that doesn't have the technology of Apple's use. It is
But counsel, doesn't opposer just have to establish that he has the right or an entitlement to use live photos to describe his product? So he doesn't have to use it. He just has to say, hey, I have the right to, I should be able to use it fairly and honestly to describe my product.
No, he with respect, he needs to show that he would be damaged in some way by Apple's use. And Apple's not saying that there couldn't be in this situation for unrelated products. There could be. We all know about the doctrines of descriptive fair use. There could be ways that somebody could use this phrase as a brand. Mr. Cow has never said to Apple what he intends with that regard, but I think it's really important if we're going to let the floodgates open with people coming in, and again, not a single, anywhere in the world, not a single other company that offers the functionality, not Google, not Samsung, not anyone has come in to say that this is a generic mark. Only this one person who has never used it and had apps he's never had, domain names he's never used for products that are not the same functionality. All they do is let you have a pre-existing photo. If you have a library of pre-existing photos, you can use the spin feature to scroll through them quickly. That is not at all what we're talking about here. And it's also prejudicial because as noted by Her Honor's description of this case, we couldn't even take Mr. Cow, because he's a citizen of Canada's, deposition on cross-examination. We had to submit written questions that he saw in advance. We couldn't follow up. Well, he had the ability to come in and take the full deposition with U.S. counsel and cross-examine Apple's head of trademarks, Mr. LaPearl. I really think that I appreciate the standard. I understand that. Apple understands that, more importantly. But if ever there was a case, given the overriding, if entitlement, if sanctions are to mean anything, I think this is the case for it. And then moving, if I would, given the time, but moving, if I would, you asked my opponent what his elevator speech was. Well, let me give you mine. My elevator speech is, this is a case about burden, and this is a case about consumer perception. It is the burden on Mr. Cow, because the examiner published this for opposition on the grounds of inherent distinctiveness. It is the burden on him to prove that by the preponderance of the evidence that the primary significance of this mark to consumers is that it's generic. It's also his burden, if he fails in that, to try to prove by the preponderance of the evidence that it's descriptive. He can't do either. He can't do either because fundamentally the evidence that he submitted does nothing to show what consumers perceive, which is the key thing. What do they perceive is this primary significance?
I would appreciate it if you would touch on both as a matter of law and then applying to the facts of this case, the distinction between the relatively new genericness precedent we have that says something is generic if it names a key aspect of the goods and services versus something being descriptive if it immediately describes a quality or feature of the goods or services. Where is the line between those two things as a matter of law, and then how would that apply potentially in this case?
Thank you, Your Honor. A generic term is one that is the name for something. If I had a chart, which we weren't able to do, a chart of what it would look like, it would be some all the way to the left, it would be wine or beer. While a descriptive mark is one that conveys an immediate idea of the ingredient quality or characteristic. When further on the spectrum is a suggestive mark, which the examiner properly found was live photos, because you needed an imagination, a thought process to figure out what this was about. And that's the key thing, because as one of Your Honor's questions pointed out, and I hate to tell people that there's no Santa Claus, but the photos are not actually alive. They are just video. All live photos are, and our specimen of use made that really clear. It's at the heart of a live photo is a beautiful 12 megapixel photo, but together with that photo are the moments just before and after it was taken, captured with movement and sound. That's what it is. That's why the genus is correct. So now look at the recent case law that you talked about. The case law, I think, is very sophisticated and helpful for all of us as trademark lawyers or trademark judges, because we look at booking.com, we look at the Elliott v. Google case, and we know that so many of the arguments that are made by Mr. Cow just don't make sense ever, and certainly under recent precedent. Why? Because a lot of the arguments, a lot of the focus of the brief and even of the argument was, well, Apple calls the resulting file, a live photo or live photos. But as we know, Apple is only doing that, the evidence shows, not in relation to Google's photos or Samsung's photos. And key to this case is the fact that Google and Samsung use motion photos as the term. They don't use live photos, they use their own words, and Microsoft uses a different word. Even Mr. Cao, both in oral argument and 26 times in their reply brief, used as the generic photo video hybrids, not live photos. But what I'm saying about those cases is those cases show that people can, refer to booking.com, and that could be a mark if it's not used generically to refer to Travelocity. And there's not anything in the case that shows that Apple, similar to Elliott v. Google, is using live photos to refer to anything other than Apple's own products. And a lot of the evidence, timely or not, that Mr. Cao submitted was evidence that showed that third parties also were using live photos specifically to refer to Apple, which is not generic use. It's the opposite of generic use. But I think that it's very important to focus on the evidence and the lack of evidence here, because we know that the burden is on Mr. Cao. So, and we know that in Merrill Lynch, there's various types of evidence that this court looks to. So what do we know that Cao has and doesn't have? First, Cao has no purchaser testimony, like declarations or oral examination or anything from actual consumers. Second, it has no survey evidence serving as a proxy for what people actually think. Third, it has no dictionary definitions. This term's been around, live photos has been in the world very heraldly since 2015. There's plenty of time. We always read news stories about, new to the Oxford Dictionary this year is X word. Live photos not one of them. The only 2 dictionaries of the 22 submitted that mention live photos did so only with regard to Apple, which proves our point that it's seen as a brand. Fourth, the press usage favors Apple. The press usage shows what the primary significance of the mark might be. Apple submitted, we could have submitted more, but we know we're not supposed to inundate the board. Maybe we did a little anyway, but we gave you 75 articles, not from like China Biz News, but from the 5 leading newspapers in America with the widest circulation. And we explained what that circulation was. And other newspapers in the top 25, including the Houston Chronicle, and some of us are in Texas right now. And what do these press things say? What do they tell us? What do they tell you as the board? First, they show that the press uses something other than live photos as the generic name. The New York Post, the New York Times uses moving pictures. The San Francisco Chronicle uses GIF-like images. Second, when reporters talk about live photos, they do it in reference to Apple. The Washington Post said that Apple offered a new feature called live photos. The New York Times took a feature called live photos, and they always do it with a capital L, a capital P. We all agree that capitalization is not key to the world and the only hill to die on. But the whole point of trademark law is to look at the context and look at what was being communicated.
Yeah,
And
how do we know how
Counsel,
consumers,
Counsel,
excuse me,
I have
how
a
do we know how
question.
consumers perceive a capital, the capital L, the capital P? There's no evidence how consumers perceive it. And despite your assertions, a lot of the evidence, it's very ambiguous as to how consumers would perceive it, especially when it's used with so many other terms, many of which are clearly not proprietary.
Counsel, I didn't see any of that evidence in the record. Is there any evidence in the record about how consumers perceive capitalization?
There's, we have said that, and I think both parties have asserted that initial capitalizations, and I think there's very many TTAB decisions that have cited the fact that initial capitalizations are one indication of brand use and that consumers are accustomed to that. But if there is ambiguity, we don't think there is because we think consumers are there, that falls on their side because they bear the burden of proof by the preponderance of the evidence. So if they're not able to show what consumers perceive, it's not a jump ball, that falls on them. The other thing is if you look at the Google Trends documents, which is in the record, and I encourage, if possible, the board to look at the actual documents, 63 TTAB View 3010, and because it says a couple of things. It shows when you do a search on Google Trends from January 1st, 2015 to September 23rd, 2020, which was the end of the period that we were talking about here when the testimony was, you will see virtually the only thing that people are searching for, all the related searches, all of them relate to Apple. So you would think if live photos was a generic term, that there would be some reference to somebody else is live photos or live photos in a generic way. Instead, it wasn't. What else does that document show? It also shows there's kind of a flat line showing virtually no one was doing any searches for live photo until September 9, 2015, and Apple's announcement, when the world exploded and suddenly, there's lots of searches for lots of period of time for live photos. To me, that is a very good proxy for showing that consumers pre-Apple, not thinking about live photos, certainly wasn't out there in any kind of big way, or you think some more people would have been searching for it. And then after Apple, lots of awareness, lots of secondary meaning, lots of acquired distinctiveness, and only with regard to Apple, not in a generic sense.
But don't we have some evidence in the record that predates Apple's adoption of the mark, some use of live photo? I'm thinking in particular, I think there was pointing to HTC Zoe feature and maybe some others.
I'm glad you asked that because that evidence is misleading. So in their original period, the only evidence that they put in was not a single piece of evidence that showed that HTC's Zoe was referred to using the phrase live photos. There was one document that I believe said living photo, but nothing else. There's one email that they don't disclose. There's one news story clipping that they use as a block quote in both of their briefs. They like it so much, but they don't tell you that it wasn't from HTC. It was a single reviewer, and it was a reviewer from, I think it was not a prominent publication. Let's put it that way. It was from hothardware.com with no indicia of any circulation or that anyone saw it. And I guess I want to go back to one of my central themes, because to me, the Baroness estate case is so vital to this. It's not just important to Apple, and obviously we want to win this proceeding, but I think vital to what the TTAB does and what the Lanham Act does, in the sense that we're living at a time when you can have virtually anything found on the internet. Again, most of the stuff was from their rebuttal period. I'm mindful of the preliminary pronouncement by this board, but to what degree? I mean, how many people are pouring through buried references post Apple in thick user manuals. What's the proof that anyone has seen them? And again, pre-Apple, the only usage was was not of live photos, but was in this way. But again, the Baroness Estate case to me is really important because it says you need to look not just at the quantity of the evidence, but the quality of the evidence. And that does include, I'm not saying that there's a bright line rule, but there are cases that say if the use is overbroad, from overseas, you can take that into account and think, well, what's the proof that anyone saw it in America? And the party offering it should be able to make some proof of that. They should put in circulation figures. They should be able to do something to say that this was a really hot site that everybody looked at. And they didn't do that, nor should you be able to lard up your files with duplicate entries and things like that, because otherwise it puts the TTAB, as you would know better than I, in a position of having to pour through all these documents and having to weigh an arcane reference post Apple's launch by an infringer. An infringer, by the way, though Apple, as Mr. LaPearl testified, has police and is trying to infringe and these apps are being taken down, that Apple's infringement is being hindered by the fact that Mr. Cow has prevented it from getting its trademark. But how do you weigh like a random article of unknown circulation of an unknown, hothardware.com or whatever it is, and then you compare that, or I think you should weigh it and compare it with Apple's evidence, which is
Counsel, we're not looking just at one random third-party usage. We're looking at, let's say, there were hundreds of third-party usage reviews, third-party use in the record. So I think Poser's counsel was correct, is that we don't look at each individual piece of evidence, but we look at the entirety of it and say, what does the entirety of the evidence show us? Taking into account your argument that there's no circulation data or how many consumers were aware of it.
Well, the evidence is that, as I said, that there was not use pre-Apple's launch, and after use, and I'm happy to go it. LG, no evidence that LG ever used live photos prior to Apple. It looks like it's a Korean company that's trying to copy Apple's rights. It's an infringer. The law is clear that infringing use
but there's no evidence. There's no evidence that they're infringing. They probably think it's a descriptive or generic term. There's no evidence in the record that that Apple has sent any notices. Hey, this is our trademark. Stop using it.
Well, we couldn't, Your Honor. That's part of the problem, because we did say that we policed live photos, but they didn't say anything about Lenovo till the rebuttal period. So we couldn't investigate. We couldn't call Lenovo. We couldn't, cross-examine to the extent we could on written questions, Mr. Cow, with regard to it. The same with regard to
wait a minute, counsel. There's lots of third party. I mean, part of your case could have been, hey, we policed this. Here's evidence that we have sent objection letters, and here's people who have said, okay, sorry, we didn't realize it was your trademark. And if they said we didn't realize it was your trademark, isn't that evidence that it might be considered generic or descriptive use, and that they're backing off only because they don't want to take Apple on?
I hear what you say, Your Honor, but again, we were reacting to the case that was presented. And the case that was presented in the opening brief, their opening submissions, the only thing they put in was a single document that said that LG was using something in the United Kingdom, not in the United States. We put in evidence, as Ms. Lear-Pearl said, that we have policed, and that 6 of the 10 apps that they cited were taken down and no longer existed. And the other 4 apps, as the record shows, were for not the same functionality. But I think that, and then you look at HTC. HTC never used live photos to describe its product. It's called its software Zoe and its resulting product Zoe's. ZTE, all after Apple's launch. There was only one article and one press release in connection with that and its opening trial brief. And then when you do look at, we weren't able to deal with the additional documents on XTZ, but just looking at the face of them, again, they're all hearsay too, because the dates and the times and even whether a product was launched would all be hearsay. But what we know from Mr. Cow's own evidence is that those products are unavailable and not in stock. So they can't be serving, the same degree as the rest of this.
Could we shift gears? I just, before we run out of time, I wondered if you might address a question I have about the Section 2F claim of acquired distinctiveness. I'm wondering, since if I understand the live photos correctly, it's a feature of the iPhone that's provided with the phone and is not offered or sold separately, particularly when we're looking at 2F evidence like sales figures or advertising. How do we separate out the live photos feature from the iPhone that it comes with?
That's a good question, Your Honor. I guess I would not say if it were a bad question, but it's still a good question, Your Honor. I'm glad to address it. And that is because this was not a hidden feature. I know counsel made that argument. Well, the iPhone, the iPad, the iMac may have had billions and billions and billions of sales in the United States, but none of that's relevant, is their argument, because the live photos feature is just part of it. And I think that that's both wrong legally and also unfair. And the distinction is, this wasn't just something that was kind of this hidden part of it. As the undisputed evidence shows, it was the live photos feature was the main thing talked about, in our announcement. It was the main thing. Reviews were 6.9. A single review of the live photos feature had 6.9 million views. Millions of views with regard to the opening announcement. A special television commercial just about live photos. Now, I appreciate, I guess the board could say, well, I don't know if I want to give credit every single sale as related to this. I think that would be wrong. But the point is, we're dealing with hundreds and hundreds of billions of sales. So just give me 100 billion sales, and I think that would be more than enough to show that the sales success for a product that was so touted and advertised and seen by consumers. And again, that is, to me, one of the fundamental differences in this case between Apple's evidence and Mr. Cow's evidence, is that Apple did provide not just circulation figures, but evidence of the consumer impressions of its commercials, the number of downloads, the number of sales, as opposed to just amorphous evidence about, well, there's this third party out there, but at least one of those third parties, one of those phones, may have been the XTE phone. I think their own document showed, it's hearsay, but showed that it was ranked 450,000th of smartphone sales. 450,000. I don't think that's enough to show a post Apple announcement product that Apple didn't get the chance to fully rebut is generic. I mean, it goes to the primary significance, and that's ultimately what this case is about. And similar to the Elliott v. Google case, there's enormous evidence of primary significance. I also want to say, well, we've been speaking, we talked about standing, we talked about genericness. I do want to say just something about suggestiveness, in the sense that, again, it's their burden to prove it's descriptive. This is an imaginative phrase. I think the two cases that I commend to the board are the Lookbook Live case and the Vocal Bus case, because both of them were cases where this board found as suggestive the incongruous pairing of something alive with something dead and inanimate. And that's what this case is about. It takes some imagination to think about, well, what makes it this way? And that's why other people use other things. To me, that's the other key thing about this case, if I were the board, that I would consider. That, you know, the fact that Samsung and Google use motion photos and Microsoft uses living images and people use other things. And in their reply brief, they talk, even our opponent talks about photo video hybrids as the generic. I just think it's really
Minute and a half if you want to finish up.
Fair enough. And I guess to finish up, I just would like to say just briefly something about, yes, this case is really important to Apple, but I think it's really important, as I alluded to a couple of times, to policy. One substantive thing before I say that, and that is it's suggestive, but even if it weren't even if the court found it descriptive, the overwhelming evidence we believe we submitted with regard to secondary meaning from Google Trends, from unsolicited media, we think puts pay to that argument. But in terms of policy, there are three real policy issues that this case deals with. You know, one is whether it's appropriate under the American Meat Institute case for someone to be able to put all that kind of evidence in on rebuttal. I'm not going to say more about it because the court has ruled, but that's an important point for people reading this opinion, because it could really affect people like me who have to litigate these cases, and more importantly, our clients who shouldn't be in this position. Second, it's really important to deal with the Baroness estate thinking and the in-re country music thinking about the quality and the nature of the evidence, so that if you're not just weighing random things on the internet. And then finally, if ever there was a case to really consider what is meant by entitlement, this is the case. I think this is a case about Mr. Cow feeling entitled, but not legally meeting the test for entitlement. Thank you very much.
Thank you, counsel. Thank you. Mr. Levy, rebuttal. 5 minutes.
Thank you, Your Honor. So I'm going to move quickly because there are a lot of points that Ms. Sindali raised, but I'm going to focus on some key ones. One, I think a lot of Ms. Sindali's comments related to the fact that there are a whole lot of references to live photos in connection with Apple. No question about it. But the point is that that's hardly surprising given Apple's enormous marketing prowess and the popularity of the iPhone. But as the board commented very recently in the smart keyboard case, it doesn't matter. If live photos is generic for the key aspect of the live photo software feature, the mark's generic. And however, whatever market saturation Apple does to get people talking about live photos in connection with Apple does not undermine the generic nature of the term. As the board wrote in the smart keyboard case, no amount of evidence can transform a generic term into a registrable trademark. Of course, citing the seminal log cabin homes case with expenditures of $4 million a year. It doesn't matter how much Apple spends in marketing to try to convince people that that live photos is associated with Apple. If live photos is rather the generic name of the media produced by the live photos feature, which Apple says it is, then it doesn't matter.
Applicant's counsel says that opposer doesn't have standing, in particular because he's not not using a product that's similar to an applicant's product. So he's not a competitor. It's not the same product. He doesn't have a need to use it. He's, so he doesn't have the right to use it. How do you respond to that?
Well, she's wrong, Your Honor. Mr. Cow does have products that incorporate that animate still images, and for which he has the right to describe those things as live photos. And indeed, standing is presumed when the mark is allegedly descriptive and the opposer has a sufficient interest in using the descriptive term in his business. There is, as you pointed out, Your Honor, there is no requirement to use the mark. Cow clearly meets this standard. He created mobile applications that add animation to still images. He wants to use live photos in its ordinary sense to refer to a key feature of his applications, namely adding animation to still images. He owns 2 domain names that he purchased years before Apple. Ms. Sandali wants to portray my client as this interloper. Well, guess what? My client used live photos before Apple did. My client adopted those names for his domains in which he wanted to use those domains in connection with promoting his product, to use that term descriptively, if not generically. And the only reason he hasn't done it is the very reasonable position that he doesn't want to get sued by Apple. And he doesn't have to use it, as the board has said a number of times. This is not even a hard case of standing. This is or the correct term, as Judge Bergsman pointed out. But this isn't even a hard case. This is an easy case. His motives are legitimate. All the key conduct giving his standing happened before Apple even adopted the term. And contrary to what Apple says in its briefing, completely wrong, he never listed his domains for sale. That was the prior owner of the domains. So, Apple wants to make it look like he's trying to hold Apple hostage. The record doesn't support that, Your Honors. Okay,
your time's almost up. Please finish up.
Yeah. So just finally, a final word on the rebuttal evidence. The rebuttal evidence in this case is clearly rebuttal evidence according to the standard in the Apollo case we cited in our briefs. We may put in rebuttal evidence to explain, repel, counteract, or disprove the evidence of the adverse party. That's exactly what we did. All of it is in response to Mr. LaPearl's detailed and argumentative declaration submitted in Apple's case in chief. There is the fact that the evidence could theoretically have been offered in the opening period does not preclude its admission as rebuttal under Apollo. Thank you, Your Honors.
Thank you, counsel. It was a very good argument, and I would also like to commend both of you because it was a very well litigated case. So this concludes our hearing. We can log off now. Thank you.
Hello, everybody, and thank you very much for joining us for that fantastic and very interesting and engaging live oral hearing. We are going to be going to break right now, and we're going to be going to break for the next 15 minutes, and we will be back at 12:40 p.m. Central Time. All right. So, and at that time, we will be able to show you the keyword again in case you missed it. Thank you. We'll see you in about 15 minutes.